May I please your lordship? Lordship, pertaining to item number 22 of today's listing, and with the consent of opposite party, lordship, I'm requesting this honorable court for adjournment of the matter, lordship. Owing to personal difficulties of the main conducting counsel,
Mr.
J. Lomi,
Lomi, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty. He has also informed the counsel for the other side. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
I'll your best, lordship.
May please your lordship, I beg to mention for listing unlisted matter filed today itself.
What is the matter?
In a pre-arrest bail, I am owner of a vehicle. I am cooperated with the investigating authority and recorded my statement. And at the time of filing charge sheet, showing absconder, filed a charge sheet against me. My statement has been recorded.
Now, whether the court has issued summons to you,
Someone issued.
what is the date?
Next date 26.
26th
September.
of
Yes,
26th of August,
26 September
26
2021.
September.
Ah.
Then no urgency on Monday.
Lordship, I am extremely sorry to say that before 1 hour, over telephone informed me my uncle expired. I am coming from Guwahati. So Lordship, kindly.
But there is no urgency in the case. Oh, okay. At 2. Okay, at 2.
Yes, Lordship. Kindly.
Your Honor, I'm back to mention item number 5 and 13 for adjournment.
5 and 13.
I'm appearing on behalf of SK Diori, sir. Item number 5 and 13 are analogous matters. 5 and 13.
Heard Mr. M. Pertin, learned counsel for the petitioner, who prays for an adjournment.
Your Honor, it may be fixed on 19th of September because the
You have
God.
informed the other side.
Yes, I have informed. I've taken consent from the other side.
Yes. He also submits that he has informed the learned counsel for the respondent regarding his prayer for adjournment. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed again on 19th of September. 19th of September.
Much obliged, Your Honor.
19th of September. You have to call the computer person. This.
Your Lordship, I'm filing a criminal petition under section 528 of BNSS for quashing of the matter, Your Honor. Sunil Bagwar versus State of AP, Bandardeva PS case 117. Your Honor. So matter may be put up today itself, Your Honor. Your Honor, Your Honor, there is no urgency, but matter may be put up today. Okay, Your Honor. Obliged, Your Honor. Well, Lordship, I beg to mention item number 15. 15. On behalf of learned counsel, the Deep Congress, Lordship. 15. Matter may be adjourned for to 2 weeks.
Oh, no. Oh, actually, is okay now. Ah, yes, item number 15. What is the prayer?
2 weeks of time.
Heard, Mr. What is your name?
K. Yadav.
Write his name. Learned counsel for the petitioner who, learned counsel for the appellant who prays. On what ground you are praying?
Conducting counsel Deep Pangang is could not able to attend according to the
But
because of his
this is in orders column only. We will see what is, why it is has been.
Lordship, in this matter, we have to take a step upon respondent number 2.
So you wait till the matter is called. We will pass orders when the matter is called. Okay,
Lordship, item 19, Lordship,
yes.
yes, supplementary hearing.
What is the prayer?
2 weeks of adjournment for 2 weeks.
Heard, Mrs. What is your name?
K. Yadav.
Yeah, hello, learned counsel for the appeal revision is praying for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
Lordship, item 19, 20, and 21 is a connected matter, Lordship.
Okay, oh, same orders.
Last, Lordship.
Malad, may I mention item number, Malad, item number, Malad, so 2, Malad. This is RHA, Malad. I've taken the consent of the other party, Malad, the counsel for the Malad. Owing to Malad, my personal difficulty, Malad, I could not,
You are
I'm for the sole respondent,
sole respondent.
Malad,
M. Kato,
Malad.
you have taken consent from the
Yes.
appeal.
Yes, Malad. I'm for the
Heard, Mr. M. Kato, learned counsel for the respondent who prays for an adjournment on the ground of personal difficulty.
Malad.
Mr. K. Tari,
yes, Malad.
learned counsel for the appellant does not opposes the prayer. Hence, the prayer is allowed. Let this matter be listed
After 2 weeks.
after 2 weeks on a date to be fixed by registry.
Malad. And Malad, item number, Malad, 14. In this matter, Malad, I am, Malad, looking for the, Malad, the counsel for the petitioner. But they are basically, Malad, the Guwahati-based lawyer. And the person's names, the Lanet Brain, Malad, Koratama has been shown in the cause list, but he is not, Malad, directly connected to the case, Malad. So therefore, Malad, the agent, when matter comes, Malad, the matter may be agent or, Malad, may have,
Malad.
Malad, 4 weeks time may be granted.
Lords, I appear virtually, my lords, in item number 14 for the petitioners, my lords, Advocate Anshuman Sahni.
What is your prayer?
Please, my lords, I believe my learned colleague is seeking an adjournment
Madam.
today. My lords.
Yes.
Yes, ma'am.
My lords, if I may only point out that this matter has to be heard and argued finally, my lords. My lords, several dates the respondent number 2 and 3 have taken time to file their
Okay.
affidavit in response.
Admittedly, ma'am.
You
On
have
the
not
last
paid.
date of
No.
hearing, they were given a final opportunity. My lords, if they wish to file, all right. Otherwise, my lords may fix it for arguments. And my lords, there is a interim
Okay.
order which was.
Okay, we'll take it up when the matter is called up.
Malad,
We'll,
Since they are
will-
also consenting, the matter may be adjourned for 4 weeks time. In the meantime, Malad will come with the detailed affidavit, Malad.
the matter
Malad,
will be fixed
difficult-
for hearing.
No, Malad, first of all, Malad, the
No,
affidavit.
his prayer is that it should be,
After Malad, after 4 weeks, matter may be Malad fixed for the hearing, Malad. Malad,
Malad,
difficulty is the person's, the Malad, the impairment complainant. He is Malad taking care of his and the ailing father, who is.
but he's the
bedridden.
counsel, you are counsel for,
The respondent matter, impairment respondent matter. This is basically for quashing of the matter, the FIR as well as the FIR matter. So
now
therefore,
today the matters has come up in orders column.
Malad,
Why?
for Malad, the filing necessary affidavit, Malad.
You have not filed affidavit.
No, Malad.
When will you file?
Malad, 4 weeks time may be
But
granted.
on last occasion, last opportunity was
Malad,
granted.
admittedly, Malad. The Malad impairment complainant, he is taking care of his ailing father, who is
Then we
bedridden.
will fix it for hearing. In the meanwhile, you file it.
Malad, first, at least affidavit has to be filed, no? And maybe they will get the opportunity to.
Heard, Mr. What is your name? M. Kato,
Mine.
learned counsel for the respondent. Also heard, Mr. What is your name?
My lords, Anshuman Sahni.
Mr. Anshuman Shani, learned counsel appearing for the petitioner. Mr. Kato, learned counsel for the respondent submits that though on last occasion, the respondent were directed to file affidavit in opposition.
My lord.
However, why you could not file?
My lord, owing to, my lord, the busy of the implement complainant.
Owing, however, owing to the
My lord,
some
he is,
personal
my lord,
difficulties of
yes.
the informant respondent, the affidavit in opposition could not be filed. And he prays for some more time for filing the same. On the other hand, learned counsel for the petitioner has submitted that on more than one occasions, the petitioner was given opportunity to file affidavit in opposition. Hence, a date for final hearing may be fixed. Stop. I have considered the submissions made by learned counsel for the parties. Considering the submissions made, one more chance for filing affidavit in opposition. This is a 227 matter or 482.
482, my lord.
482, my lord.
Before the state lawsuit, respondent number one lawsuit.
Show the presence of Ms. Hage also. The respondent is allowed to file an affidavit in opposition within a period of
4 weeks.
4 weeks. It is hereby made clear that no further indulgence would be granted to the petitioner on his failure to file
Right.
the affidavit on the next date. And the matter would be fixed for hearing on his failure.
Keep up.
Just a very small indulgence, my lords, humbly obliged. My lords have said the petitioner to file a reply. My lords, it would read respondent 2 and 3, my lords.
Or respondent number 2 and 3.
Please. And my lords, on the previous date, on the last order, 29th of July, 2024, my lords, the hearing before the JMFC on charge, my lords, was stayed by this court. My lord, I'm only requesting that the interim order granted on the previous date may be continued, my lords, for the next date of
The
hearing.
interim order shall continue till next date.
It's deeply obliged, my lords.
Lordship, may I beg to mention one pending matter, civil revision petition. Lordship, this matter may be fixed on tomorrow. Then on the 4th of September.
Why it has not been listed?
Because the petitioner, I am on the other side. Petitioner has obtained interim order, then case has been kept pending.
Okay, on 4th.
Fourth.
Your Honor, my apologies. With respect to item number 5 and 13, interim was granted. That may be continued, Your Honor. Item number 5 and 13.
Item number 5 and 20 interim shall continue till next.
Much obliged, Your Honor.
Item number 1.
Lordship, before lordship starting this petition, lordship, may lordship, this regarding lordship, this same lordship, same kind of lordship petition is heard lordship before this honorable court. It is annexed in this dear petition. It's 19/8/24 lordship. Lordship, there are same this is same petitioner lordship, and here lordship honorable court has directed to call the scanned copy of the trial court record lordship, which is to be fixed on tomorrow lordship. So it may be
Tomorrow?
club lordship that this matter may be clubbed together and it may be heard tomorrow lordship.
Okay, tomorrow.
My lord, I think my senior RP Sharma is on in line. He will say something.
Yes, Mr. Sharma. You are not audible. You are not audible. We are fixing it tomorrow, as the connected matter is fixed tomorrow.
My lord, urgency is there, my lord.
But he is not audible. How will? What is the, even if there is an urgency, it is fixed, connected
My
matter
lord,
is fixed.
I will argue the matter. Kindly peruse the petition for a moment.
No, when the connected matter is fixed tomorrow, where the records are called for,
My lord, I am again here.
what
And-
will happen within a day?
My lord, can you see order, can you see last page, lordship? Page number 30. I am against this order.
Am I audible, my lord?
Ah, yes, now you are audible.
Yes, my lord, you will also kindly come to page 30 of the petition, my lord, that
No,
the been order.
No, Mr. Sharma, the additional public prosecutor has submitted that a connected matter is fixed tomorrow where the records are called for, and tomorrow it is fixed. So
But-
it would
But I got
be,
information by the instruction to say that the other side informant on the basis of very collusive FIR is trying to defreeze my FD and take away the money today. So my lord, let him not do it until tomorrow at least, so that both the matter can be heard tomorrow, my lord. Without hearing the other party, my money is there, fixed deposit long back deposited. The message, London message is passing the order, and the police in collaboration with the my lord informant are drawing the money, defreezing the account and taking out the money. Ex parte order, without
No,
hearing
This
me,
is-
page 30.
This
my
is
lord.
order dated 25/7 lordship, July order lordship. And here nowhere is the mention that date lordship date today will be the last date to transfer the date.
Yes, let
Before-
it be
without going to the
25/7
record,
whatever
lordship.
it is. Within time, my lord, let him not draw it until tomorrow order is passed, until the matter is heard tomorrow. I've got.
no,
Denied, my lord,
no, where is the averments to show that they will withdraw the money today itself, apart from your oral submission?
but already message been just now received from the on my client's mobile, my lord, that money is already deducted, but it
Already
is not already
deducted?
transferred to the informant. Deducted, but not transferred yet. Today it may be transferred.
No, on what basis you are saying? Because this is an order of 25th
No,
July, already
in
1
the,
month.
in the, no, my lord. Otherwise, I would have moved tomorrow only, because today in my client's mobile, my lord, which is now I am using in this argument, my lord, there he received a message from the bank. The money would be deducted and would be paid to the informant, transferred to his account. Totally without hearing the party, my lord, without hearing the affected party.
How can you
how can the
lordship pass
message
any
pass
order
from the
lordship?
Whatever it is, and what is the meaning of Jima? Can he take the money and appropriate himself? What is the provision of 457? He'll have to keep it in Jimma till the trial or inquiry is over. You cannot just file an FIR, police FIR, with one Hemanta Agarwal who is not arrested yet by the police. Why? Was not arrested yet. It is now nearly 8 months.
Okay, heard Mr.
Who took the money, 33 crore LA?
R.P.
And-
Sharma, Lanet Senior Counsel, assisted by Mr.
Hey, Hussein.
A. Hussain, Lanet Counsel for the petitioner. Also heard Ms. L. Hage, Lanet Additional Public Prosecutor. Before the matter, before the petitioner could address this court, before Lanet Counsel for the petitioner could address this court, Lanet Additional Public Prosecutor has brought to the notice of this court that a connected case, that is page number,
Page
Page
number
number
28, my lord.
It's a 28 lordship. Case
Okay.
number, criminal revision
that a
petition
connected
11
case,
2020.
that is criminal revision petition 11/2024 between the same parties and in in connection with the same case from where the order has been impugned in the instant case is fixed tomorrow, that is on 31/8/2024, where the scanned copy of trial court records have also been called for. Learned additional public prosecutor therefore submits that this matter may also be taken up along with
Okay.
the same, as it would be convenient to consider both matters together by going through the scanned copy of the case record. Stop.
Only, my lord, that the order impugned there is different one. That is dated 20th of June, my lord, 2024. Here the order is of 25/7/2024.
Learned senior counsel for the petitioner submits that the order which has been challenged in this instant criminal revision has directed the ICICI Bank Naharlagun branch to liquidate the fixed deposit of the petitioner and transfer the money deposited there to the respondent number. You have not made the respondent in,
I have mentioned, respondent Naram Rikam, I have mentioned.
huh?
Make the party respondent.
Mr. Nurang Rikam,
Yes.
you have not made him a party.
Lordship, yes, Lord, they are necessary party, they, no, they should be made.
You have
party,
not
Lordship.
made him a party.
The informant, my lord.
Informant is a necessary party. No stay in his absence. How?
Yes.
Stop. To Nurang Rikam, stop. And hence praise for staying the operation of 25 order, impugn order till tomorrow, stop. However, it appears on perusal of the revision petition that the person, namely Nurang Rikam, has not been made a party respondent in this instant revision petition. And therefore, this court is not inclined to stay the matter in his absence. Release this matter tomorrow.
My lord,
Along with,
my lord, this is my mistake, my lord. Unfortunately, I forget, my lord.
along with,
Can you allow me, my lord?
Criminal revision
along with
petition.
revision petition number 11/2024. You may rectify it before tomorrow.
Obliged, Lordship.
I'm for the respondents, your lordship.
Yes.
And I may permit, I may permit something about the facts of the case matter.
For what this matter is,
Actually, today the fixed for admission. This appeal is fixed for admission, your lordship.
substantial question of law has been framed, formulated.
This, he has, the appellant submits about the facts, whether the sufficient question of law is involved or not.
Yes.
Lordship, actually, in the last order, this order was passed by this honorable court about the depositing of 50% degree amount. But the client, my client has some that issues for like he prayed for some more time for
No,
on 9th.
in this case, whether substantial question of law, regular first appeal, okay.
Yes,
Yes.
yes, your lordship.
Okay, it is a first appeal. So it is not yet admitted as because they have not deposited the 50% of the.
Yes,
degree.
your lordship.
Let them deposit.
On
Just I would like to submit that since July 2022, the respondents have been several times for
Is there any stay?
Yes,
Is
sir.
there any stay in this?
No, no.
Then
There was
go
only a
for
order.
execution.
Yes, already filed execution, Your
Then
Lordship.
you go for that execution. Where is the problem?
But so far this appeal is concerned, the
Yeah.
party is very much harassed to appear and appear before this Lordship Court to attend this
No,
matter.
suppose if it is ultimately dismissed, we will impose costs. You will get, it will be dismissed with costs. So your execution is not affected
Ye-
by.
Yes,
having
Your
or
Lordship.
no-
But so far the appeal is concerned, the appeal is against the judgment passed by the trial court on admission. So this appeal is itself not liable, not maintainable, Your Lordship. So already the judgment passed by the honorable trial court, the page number 50, simply if Your Lordship see the judgment in page number 50, that I allow to submit Your Lordship the important parts of the judgment.
Where is the direction that you were allowed, directed to pay 50%? Are you ready for admission hearing today?
No, Lordship. I need some more time. Let me fix for a 9th. On
They are
9th, he
raising the question of maintainability of this appeal.
Yes, Your Lordship.
on 9th only.
Let them
My
come prepared.
yeah.
We'll hear the question of maintainability.
Your Lordship, in oral order passed earlier, that they have directed by this Lordship Court that to pay 50% of principal amount to this court.
Yes.
And they have taken time for depositing the same. On the last date, even they taken times for depositing
No,
the amount.
no, therefore what I am suggesting.
But so far it appears from the conduct of the parties, Your Lordship, that since July 22, they have taken time before the court. They have admitted before the court that I am going to pay. And the Honorable Trial Court has granted 10 days time for depositing. Thereafter, they again took 3 months time for depositing. This has happened in this matter, Your Lordship.
Lordship,
So there is no
order was
scope,
passed,
there is no scope to deposit the amount by the appellant in this
Okay,
matter.
on the next day,
on
on the next day, we will hear the question of maintainability. In the meanwhile, you are free to proceed with the execution case as there is no stay.
Yes,
So
Your
even if they don't deposit the 50%, there is no embargo on you.
Yes,
to
yes, Your
proceed
Lordship.
with the.
Yes, Your Lordship.
So you proceed. Now she is not ready. Therefore, we are fixing it for, I'll mention that you have raised the question of maintainability.
Yes.
It will be hard on the next.
Yes,
day.
Your Lordship.
Lordship may be on fixed for the 9th.
So they may be
because
directed to deposit
they'll be
amount.
coming here and they'll be depositing the money with appearing here in the court
When?
on 9th.
Okay. Then after 9th, we will fix it.
Yes, if Your Lordship fix the matter in 110, my another matter is fixed.
10th.
Yes, madam.
Yes.
In the meantime, direction may be given to the appellant to deposit the amount within 9 as earlier fixed by the official.
Heard Mr. C. Modi.
A.K. Misra.
Heard Mr. This is item number. Heard Mr. A.K. Mishra. No, what is your name?
Dusurilo
Heard Miss Dusurilong, learned counsel for the
petition.
appellant. Also heard Mr. A.K. Mishra, learned counsel for the respondent. Learned counsel for the appellant submits that though the appellant was directed to pay 50% of the decretal amount to the court, to this court. However, due to some difficulty, the appellant could not deposit the same and prays for time till 9th of September for depositing the said amount. On the other hand, learned counsel for the respondent has raised the question of maintainability of this appeal as the decree in the trial court was passed on admission of the defendant. Stop. Considering the submissions made by learned counsel for the parties, the appellant is allowed time till 9th of September to comply with the order of this court passed on 22/7/2024. Let this case be listed again on 10th of September,
October, Your Lordship.
10th of October.
110,
And you will deposit on,
9.
okay, on 10th of October,
Yes, Your Lordship. 9 September, up to 9 September.
10th of
9
October,
September.
And the matter may be fixed for final hearing on 110. Yes,
10th of October.
10th of, no, 110. Your Lordship.
First of October.
1st of
First of October for admission here.
Yes,
Hello.
yes.
What is this?
Your Lordship, here petition filed under 482 CRPC. Your Lordship, for causing the FR and sends the concept of the criminal trial before the CJM SEPA, Your Lordship. Your Lordship, the petition number 1 is the husband is the accused person, and petition number 2 is
Yes.
page it in last paragraph. In the light of above fact and circumstances, a prima facie case is found well established against the alleged accused.
For
also.
323.
Only charge is only 498A.
Okay, yes, Miss
Hage.
Hage. Anything? Which judgment you are relying?
Your Lordship, the judgments relying on what the one is apex code, that is the
Lakshmi Narayan.
no, Your Lordship. Narendra Singh, Your Lordship. Your Lordship, here is the case. When both the
Anything
parties
you-
settle,
Okay,
then there is minimal chances to prosecution witnesses support to the prosecution court for convict the accused. On that ground, the FR was, the proceeding is not proposed. And another case,
heard, Mr.
another case, Your Lordship, is GLT.
No, not required. PP is conceding to your prayer. And
So it is
otherwise,
also
they-
matrimonial
otherwise
issue
they
with
are
AB
staying
Lordship.
together.
Lordship,
It would not yield any result.
yes, Lordship.
Heard Mr. T. Gyadi, learned counsel for the petitioner. Also heard Miss L. Hage, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973 has been jointly filed by Shri Hopio Tajo and Srimati Mary Gyadi Tajo, who are husband and wife in relationship, for quashing the
The puppy is.
GR case number 78/2022 corresponding to SEPA WPS case number 15/22 under section 498A/323 of the Indian Penal Code, presently pending in the court of
CGM magistrate, SEPA, CGM SEPA.
Chief Judicial Magistrate SEPA. The facts relevant for consideration of the instant criminal petition are that on 29/9/2022, the petitioner number 2, Srimati Mary Gyadi Tajo, had lodged an FIR before the officer in charge of Women Police Station, SEPA, East Kameng District, inter alia, alleging that the petitioner number 1 has assaulted her and subjected her to cruelty. Stop. On receipt of the said FIR, Women PS SEPA case number
03/15. Yes.
15/2022 under section 498A/326/506 of the Indian Penal Code was registered and investigation was initiated. Stop. Ultimately, on completion of investigation, charge sheet was laid against the petitioner number 1. Petitioner number 1 under section 498A/323 of the Indian Penal Code. Stop. Learned counsel for the petitioners has submitted that after the alleged incident, both the petitioners have amicably settled their dispute amongst them, and to that effect, they have also executed a deed of agreement on 26 October 2022. And one of the stipulation in the said agreement was that the petitioner number 1 would give 80% of his monthly salary to the petitioner number 2, which, according to learned counsel for the petitioner number 1 is still following. Stop. Learned counsel for the petitioners also submits that both the petitioners have 2 sons out of their wedlock who are aged about 9 years and 6 years, and they are now leading a peaceful marital life. Stop. He submits that in view of the amicable settlement arrived at between the parties, there is unlikelihood that the pending prosecution against pending GR case number 78/22 against the petitioner number 1 would end in conviction, and therefore he submits that the said GR case may be quashed for the ends of justice. In support of his submission, the learned counsel for the petitioner has cited a ruling of the apex court in the case of Narinder Singh and others versus State of Punjab, reported in 2014 6 SCC 466. Stop. On the other hand, learned additional public prosecutor Ms. L. Hage has fairly submitted that considering the fact that the petitioners are husband and wife in relationship, and considering the fact that they have amicably arrived at a settlement amongst themselves and are now leading a peaceful marital life, there is bleak chances of
Conviction.
conviction in the instant case. and therefore she submits that it would be abuse of the process of court to continue with the said prosecution. Hence, she submits that it may be a fit case where the powers of this court under section 482 may be invoked for quashing the pending prosecution against petitioner number 1. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials on record, including the copy of settlement deed executed between the parties. Stop. This criminal revision has been filed.
Criminal petition lawsuit.
Oh, sorry. This criminal petition has been filed jointly by the petitioners who are husband and wife in relationship. And as the dispute in the pending GR case is in the nature of family dispute between spouses, which has been amicably settled by the parties, this court is in agreement with the submissions made by learned counsel for the both sides that it would be futile to proceed with the prosecution in GR case number 78/2022 as the prospect of the case resulting in conviction are very bleak. Stop. This court is of considered opinion that this is an appropriate case where the inherent powers of this court may be invoked to quash the criminal case against the petitioner number 1, stop, for the ends of justice and to prevent the abuse of the process of court. Stop. Therefore, stop. For the reasons mentioned herein above, the pending case against petitioner number 1, that is GR case number 78/2022, is hereby quashed, and this criminal petition is accordingly allowed. Bail hearing.
Service upon victim.
But they are separate petitions. They are not tagged together as.
Lordship, the case is Lordship, rearrest. Accused has been rearrested.
Rearrested.
Yes. Because they are on bail. This case has been. the
In
accused
all
has been-
three cases, all three cases.
All three cases. First of all, the accused was arrested and released on bail.
Trial
And
is
during
going
the
on.
course of trial in the CC state,
And
despite
the
of,
moreover, suggestion-
record has come.
Lordship, yes, Lordship, moreover,
Tempering the document. And because of the slight, my lord, the blotting of the ink, it may be, which is not considered by the learned special judge.
Who is respondent number 3? Headmaster.
My lord,
Respondent number 3.
3 headmaster.
Heard Mr. What?
My lord, sorry for interruption, my lord, district also changed, my lord. New district, there is Kamle district. That may be a cause for the delaying, my lord.
Yes, now you suggest what to do.
It should be, my lord, the OCPS Raga.
Heard Mr. T. Soon,
My lord.
learned counsel for the petitioner, also heard Miss L. Hage, learned additional public prosecutor. On perusal of the office note dated 29/8/2024, it appears that neither the AD card nor the unserved notices issued to respondent number 3 has yet returned back. Stop. Learned counsel for the petitioner has submitted that this is an old pending case of the year 2019, and he prays that the notices may be issued to he prays that the notices may be issued to the
Respondent 3.
respondent number 3
Through
through the officer in charge of the jurisdictional police station, that is Raga
Raga.
Police Station
in Kamla district.
in Kamle district. Stop. Considering the facts and circumstances of this case, the prayer is allowed. The petitioner shall issue fresh notice to respondent number 3. The notices are to be served through the officer in charge of Raga Police Station. Stop. Who shall, after effecting the service on the respondent number 3, submit the service report to the registry of this court before the next date fixed. The petitioner shall take steps for issuance of notice within 7 days from the date of
Well,
this.
tomorrow, my lord, not 7,
Within
tomorrow.
within 3 days from the date of this order. Let this case be listed again on 20 September.
Yes, yes.
20 September.
My lord, much obliged.
None appears for the appellant on call.
My lord, is it item number 16, my lord?
11.
I apologize, my lord. I apologize.
None appears for appellant on call. On perusal of the case record, it appears that on several earlier occasions also, the appellant was not represented by any counsel. Let this matter be listed again on 11th of September. None appears for appellant on call. None appears for the petitioner on call. Let this matter be listed again on 11th of September 2019.
Item number 15.
Yes.
Lordship, in this matter, we are supposed to take steps, fresh steps upon respondent number 2.
Respondent number 2, you have not taken steps.
Lordship?
You have not taken steps. You need some time.
Yes, 2 weeks of time.
Heard, Mr. What is your name?
Yeah, Lord.
Heard, Mr.
K. Ado, Primar Ado.
K. Ado, learned counsel for the appellant, also admits L. Hage, learned additional public prosecutor. Learned counsel for the appellant has submitted that the petitioner could not take step. Why you could not take steps? Reason? There has to be some reason. What is the reason? You have not gone through the order. There must be some reasons. Or that you have ignored the court's order. So if there is a genuine reason, then I will allow it. Otherwise I will not allow it. You take time. You take some time and find out a reason. I'll take it up as next item. Okay? If you fail to show a reason which convinces the court, you may get adverse order. You take some time. After the next item, I will take it up again.
Item number 16 and 17.
Made to the lawsuit.
Yes.
My lord, I'm appearing for, my lord, I filed this applicant, my lord. My lord, would recall day before yesterday, my lord, this coercive order, coercive action order was extended, my lord.
Who is appearing for petitioner? 16. You are for?
My lord, I am for respondent in the main criminal petition. I am for respondent number 2 and 3, my lord. And here I am the applicant, my lord. May I submit, my lord?
Respondent number
No,
2
just a
have
minute.
filed lordship.
Mr. H.K. Jamo,
Okay.
who appeared for the petitioner yesterday?
The day for yesterday, my lord. H.K. Jammu, my lord. My lord,
Yes, you make your submission.
yes, my lord. My lord, what has happened in this? My lord, I have filed a complaint petition. I have filed a petition before the Bhalupur PS, and the said FIR had been registered against the petitioners, criminal against the petitioners. The Honorable Court of
What is the dispute?
My lord, the dispute is this, my lord. The facts of the case is such, my lord, that during the traveling of the husband.
After this, in the meanwhile, you furnish, she has to go through also.
Lordship.
At 2, we will take it up.
Lordship. Like.
What is this? Next item is?
Number 23.
Yes.
Your Lordship, this matter has been filed, praying for setting aside and questioning of impugned judgment dated 7/9/2021 and order dated 8/9/2021, whereby the convict was convicted to a term of 3.
Lordship, I was informed, Lordship, by the additional PPK at the Lordship. He was handling this matter that this opposite party will take adjournment today, Lordship.
You are ready today. You are ready.
Your Lordship, to some extent.
No, not to some extent. Either you have to be ready or not ready. Ready? Are you ready to argue?
Your Lordship, not fully.
Then get fully ready. Let the Mr. Ete come.
Lordship.
Heard. What is your name?
C. Bangsia.
Heard Miss C. Chanya,
Yes, Your Lordship.
C. Bangsia. How to pronounce the title?
Bangsia.
Bangsia.
Yes, Your Lordship.
Heard Miss Chanya Bangsia, learned counsel for the appellant. Also heard Miss L. Hage, learned additional public prosecutor. Learned counsel for the appellant has submitted that she needs some more time to get fully prepared before she argues this case. On the other hand, learned additional public prosecutor has also submitted that another additional public prosecutor, namely Mr. T. Ete, is handling this case. Stop considering the submissions made by learned counsel for both the sides. Let this matter be listed again after 2 weeks on a date to be fixed by registry.
Yes, Your Lordship.
Like this.
Item number 24.
May I present, Lordship? Lordship, I'd like to place one more citation.
You have placed any citation yesterday? Yesterday you have placed
Yes. Manjura Bera. And one is of Guwahati High Court.
Manjura Beha. Manjuri Beha. No, refresh, please refresh. The facts, I remember little bit that the dispute is as regards
The
compensation,
under two
the
heads.
head of the
Yes,
compensation.
ma'am.
Whether it is to be, your submission was,
They're
it has
entitled
to be
loss of
loss
state.
of estate.
Yes.
His submission is that nowhere it is mentioned that loss of dependency is nowhere mentioned. That is your submission.
Since I'm a legal representative of the government,
So
yeah, but, my lord, the compensation has been, my lord.
compensation for what?
My lord, compensation for, my lord, I have come to that point, my lord. My lord, let him first, my lord, submit, and thereafter I will come to that point. My lord.
What is there in Manjuri Bera's case?
Manjuri, Bera Lordship, in that case, the married daughter had filed a claim petition. And there, she had claimed for a loss of dependency. And in that case, my lord, the apex court held that as she is being a legal representative, she is entitled to maintenance, but not under the head loss of dependency. She is entitled to compensation under the head loss of state. And my lord, I place one more judgment, that is of Karnataka High Court, Kullappa versus Reliance General Insurance Co.
Yes, this is more clear, I think.
My lord, I've underlined the relevant. Lordship, in this case, kindly see paragraph 6, issue number 2. Here the issue was whether the claimants are dependent on the income of the deceased.
In which case?
My
In
lord,
the case which you have cited?
Yes, my lord, is Kullappa.
Yes.
Paragraph 6. The issues, my lord. Issue number 2. Whether petitioners prove that they are legal representative of the deceased and they are depending on the income of the deceased.
Yes.
My lord, please come to paragraph 11, I'm sorry, my lord, paragraph 12. Paragraph 12, Lordship, paragraph, the last paragraph. Where it? Lordship, here it says that dependency must be established in order to claim compensation.
Where? Para?
Para 12. Paragraph 12, Lordship, the last stanza on the next page.
Para numbering is not proper. Last stanza is on close reading.
Yes, Lordship.
Yes.
The Lordship, here it states that dependency must be established. And in the instead case, during cross-examination, the court found that the claimants are independently working.
There is only one claimant. Oh, no, in this case.
Yes.
In this case. So then,
Well, here it is held that they are independent, so they are not dependent on the income of the mother.
okay.
So they were awarded compensation under the head loss of state. My lord, in paragraph
Now, what
14
is loss of estate?
My lord, loss of state is the saving of the accused. Not, I mean, I'm sorry, of the deceased.
Now, suppose in this case, the income of the deceased is assessed to be 100 rupees.
Yes.
100 rupees.
Yes, Lordship.
And because he was a bachelor, he spent 50% of his income on his own earning.
Yes.
So 50% is deducted. What remains, 50 rupees is remaining. Then,
Lordship.
and now let me put question. You listen to the question
Yes.
carefully. Only then you can. Then 50 rupees remains after deducting 50%. Now, as he has no dependent,
Yes, Lord.
he need not to spend anything on his dependents. Therefore, this 50 rupees is saved by him.
Yes.
Then if this 50 is saved by him, it will become his savings. After death, it will become his estate. It will go to,
No, Lordship, for calculating loss of estate, it's different. Supposing he is unmarried and he's a bachelor, the presumption is that he'll be spending more than 50%.
in case of loss of estate.
Yeah. Yes, Lordship. Lordship will.
How much he will be spending?
Lordship, 75% is deducted.
Where?
Or conversely, otherwise, total income, out of total income, 25% is taken as saving.
Where is the law? Any guideline case?
My lord, the calculation is here in this Kullappa case.
Where?
Para 15.
Para?
Para 15.
Because to my understanding, the calculation in case of loss of dependency and loss of estate may be similar.
Yes, my lord, the
What remains?
calculation similar, Lordship. In loss of dependency, the remaining amount is the contribution to the family.
Yes.
And in loss of estate is from the
Remaining amount?
From the total amount you earn, out of that 25% is calculated to be the saving. And the saving
No,
is,
what is the basis? Why only 25%? If he spends 50% on himself, 50% is saving.
Yes, ma'am.
No, I'm not coming to a conclusion.
Yes,
I'm
ma'am.
just putting questions.
Yes, ma'am.
To what is the basis? Why out of remaining 50%, he will spend, he will save only 25%?
my lord, there
What is the
no-
logic? I just want to understand the logic. Do you have any case where this logic has been explained?
My lord, as far as I've come across the cases, usually in laws of state, 15% to 25% is awarded.
There has to be
And-
some logic. I just want to know the
My lord,
logic.
it's calculation of compensation, you know, we cannot lay down exact amount, what should be.
But it has to be logical because to assess the just compensation,
No, lordship, in this case, some person, they might be spending more than 50% also.
maybe,
Some may be spending
maybe, but
30 also, so.
because of the various
Yes, my lord,
judgments,
so that we cannot
it has
ascertain the
been,
exact
it
amount.
has been
So-
standardized to some extent, how much is to be deducted. Because every individual would be spending differently. Even if you are assessing that 50% be deducted for personal expenses, there are people who don't spend 50% of their earning on themselves.
Yes.
They
Yes.
spend only 15%. Still, to standardize it, a specific amount is taken. Now it is accepted. How much is to be deducted in case of a bachelor? How much if he has 2 dependents? How much if he has 3, 4 dependents?
Lordship, even in this case, supposing, if this was a bachelor and if he had many dependents, then it's not necessary that 50 should be deducted.
Yes, then
So less than 50 also.
less
should be
than
deducted,
50 has to be
depending on the factors of
dependents.
prison of-
Yes, correct, correct. Now, in this case, I agree to your submission to the extent that tentatively agree. I have not passed yet orders. Tentatively agree that unless there is loss of dependency, after hearing him, I may change also. That unless there is a loss of dependency, unless the claimant is dependent on the income of the deceased, he may not claim a compensation against loss of dependency head. He will only get compensation against the head of loss of estate.
Yes,
Now, estate is the savings which he would have done
Yes,
had he been
Alive.
alive. So a calculation is to be done.
My lord, I'd like to rely on one more case, Lordship. Here tribunal has awarded under the head loss of state. And the High Court has reversed it and awarded compensation under the head loss of dependency. And Lordship, here, the calculation we clear from this.
Oh. Where is the calculation? Paragraph,
I think the paragraph might differ because I've got it printed from the library just now and my copy.
no, you, starting paragraph, you may,
Lordship, if the paragraphs are same, it's paragraph 5. Here, Lordship, this is a calculation for loss of state, paragraph 5, and para 23 is a loss of dependency, the calculation.
Here 15% was awarded. No, actually, I am on the logic. Why some courts are giving 15%, some are giving 25% against loss of state? What is the reason? What is the logic? How to fix quantum for assessing compensation against the head loss of state? That was my query. Now, why have you shown this judgment?
And usually all the judgments, just 15, 20, 25.
No, what is your submission in this case? In the present case, how much it should be?
25%.
And logic is because in many cases,
Yes.
25% is. But, okay. Any other submission?
My lord, my prayer is since the claimant is not dependent on the disease, it's not impacted compensation under the law of dependency, regarding compensation and the loss of state. So the implicit judgment may be modified to that extent.
Yes, what is your submission?
Ma'am, please. My lord, if I recollect my yesterday's submission, my lord.
Yes.
My lord, my son, the ground which is urged by the appellant in this appeal, my lord, is that, my lord, the claimant is not dependent of the deceased person first. That is the account. And my lord, the learned tribunal has given the compensation under the head of loss of dependency. And their submission is that by giving compensation under head of loss of dependency, that is not a right decision. It should be under loss of state, at the head of
Yes,
the
correct.
state. Yes. My lord, I have submitted, my lord. This appeal petition itself is misconceived, as I submitted earlier. My lord, why I am submitting so much? My lord, this learned tribunal has given the claimant a compensation amount, not on the basis that the claimant is dependent on the deceased person. It was given on the basis that he is legal representative of the dependent. It is not given as he is dependent on claimant. That's why this compensation is given to me. My lord, if we go to the judgment, my lord, it is given on the basis that he is legal representative of the defendant, my lord. And my as I have, my lord, already placed the ruling of Honorable Appellate in Sarla Verma case. In Sarla Verma case, my lord, three factors has been considered. The proposition which has been, my lord, given in Sarla Verma case, my lord, is what will be the method for computing, my lord, method of computation, my lord, to give a just and fair compensation, my lord. So to that effect, my lord, Sarla Verma case, my lord, three heads are given. 3 points are given. Page, my lord, page 6, my lord. Sarla Verma versus, my lord, Delhi Transport, DTC, page 6, paragraph 9. May I read, my lord?
Yes.
Basically, only 3 facts need to be established by the claimant for assessing compensation in case of death. 1, age of the deceased. B, income of the deceased. And C, the number of dependents. Now, my lord, regarding age of the deceased, my lord, that is not disputed. Regarding income of the deceased, that is not disputed. Now, my lord, C. What is my humble submission is, my lord? I am not in this part C, my lord.
Yes, just a minute,
Yes,
Mr.
my lord.
Tamin. You are Mr. Kato or Tamin? Kato.
Yes.
You yesterday submitted that you will give a calculation.
Yes.
Have you prepared that? Whether
The calculation will be clear in this.
No, in this case which we are considering now,
Yes.
if we concede to your submission, what would be the calculation?
Lordship, I'll make the calculation.
Make it now.
Okay.
Because till I hear the other side, you can prepare that
Okay, yes.
calculation.
Now, my lord, this
Or
regarding.
you may give it to me within an hour.
Yes.
Within an hour.
Yes. Now, my lord, as regarding C, the number of dependents. Now, my lord, in my humble submission, my lord, in humble understanding, this C, my lord, number of dependents. Here comes, my lord, in my humble submission, my lord, loss of dependency is not, my lord, can be, my lord, similar as the, for claiming compensation, one should be dependent. This is not meaning of loss of dependency. Loss of dependency is, my lord, in my humble submission, is loss of pecuniary, my lord, income, which has been, my lord, lost by the disease, my lord. And now, my lord, if there is some dependent, my lord, now how it will be calculated? That is given in, my lord, this Sarla Verma case, my lord, which is 8, page, my lord, 7, paragraph 12. That means deduction, my lord, how it should be, my lord, computed, my lord. Para 12, my lord, page 7. May I read, my lord? We have already noted that the personal and living expenses of the deceased should be deducted from the income to arrive at the contribution to the dependent. My lord, what it says, my lord? If a person has a certain sum of, my lord, income, that has to be deducted subject to number of dependents. In this case, my lord, since the claimant deceased is bachelor, therefore, my lord, 50% of salary has been deducted.
Okay, against what? Why it is deducted?
Because of his, my lord, personal expenses.
Personal
expenses.
Okay.
Thereafter, my lord, had it been, my lord, given me as a dependent, my lord, it should be 1/3, my lord. 1/3, in my humble submission, means 1/3 of the total salary will be deducted, my lord. Suppose, my lord, 10,000, my lord. 10,000, 1/3 of 10,000 should be deducted, my lord. And remaining amount will be calculated in the compensation, total compensation, my lord, which should be assessed. That is my submission, my lord. What is given in this para 12, my lord? May I read, my lord? We have already noticed that the personal and living expenses of this should be deducted from the income arrived to the contribution to. No evidence need to be, my lord. I will come directly, my lord. 1, 2, 3, 4, 5. From down, my lord, paragraph 1, 2, 3, 4, 5. Para 5 from last, my lord, from down. My lord. Therefore, it becomes necessary to standardize the deduction to be made under the head of personal living expenses of deceased. This lead to a practice of deducting to the personal living of deceased 1/3 of the income if the deceased was married, and 1/2 of 50% of income if the deceased was a bachelor. This practice was evolved out of experience, logic, and convenience. In fact, 1/3 deduction got still recognition under second schedule of the Act in respect of claims under section 163A of the MB Act 1980. Well, what I'm submitting is this. Well, this deduction, my lord, will be made in terms of this para 12 of the Sarla Verma case. My lord, there is numerous of judgments, my lord, given by the different high courts as well as, my lord, our Honorable Supreme Court. But the decision given in Sarla Verma case, that has been, my lord, concurred by three-judge bench in Resma Kumari case, and thereafter it was, my lord, again, my lord, it was again, my lord, taken into consideration before the five-bench judge of the Honorable Supreme Court in Prene Setima. And the formulation, the methodology which has been, my lord, given in this Sarla Verma case has been, my lord, upheld, my lord. Yes, my lord. And now, my lord, next, my lord, since my learned friend is, my lord, submitting about the laws, it should be given under the head of laws of the state, my lord. Since I am not a dependent, I'm not claiming the claim. My claim is not on the basis of my dependency. It is on the basis of that I'm a legal representative. Even then, my lord, I'm not a dependent or depending on the disease, my lord. I will be, my lord, compensated under head of laws of dependency. One judgment I will place, my lord.
No, what you submitted that even if you are not dependent.
Yes, my lord.
Still.
Still, my lord. But calculation, what the calculation which has been taken by the learner, this, my lord, tribunal is right calculation. That's why, my lord, I have not filed any cross appeal, my lord. Since I am, my lord, concede to their judgment, my lord. Here, my lord, the locus standi of the legal representative has been challenged, my lord. Because they are legal representative, therefore, they are not, my lord, entitled. They are not, my lord. They have no right to file a claim petition under section 166 of MB Act. My lord, may I take your lawsuit to page 5 now? Paragraph 14. This is regarding, my lord, paragraph 14 is regarding the legal representative. That is not disputed, my lord. So I need not to border your lordship to this point. Thereafter, my lord, now 15, my lord. Paragraph 15, my lord. May I read, my lord?
Yes.
It is thus settled by now that the legal representative of the deceased have a right to apply for compensation. Having said that, it must be necessary to follow that even the major married and earning sons of the deceased, being legal representatives, have a right to apply for compensation, and it would be bounden duty of the tribunal to consider the application irrespective of the fact whether the concerned legal representative are fully dependent on deceased or not. Limit the claims towards conventional head only. One of this conventional head only, that means this loss of statement. It should not be matter leave it only to the conventional head, means loss of state. The evidence on record in the present case will suggest that the claimant were working as an agricultural laborer on a contract basis and were earning meager income between 1 lakh and 1 lakh 50 per annum. In that sense, they were largely dependent on the earning of their mother and in fact were staying with her to meet
No,
an
no.
ex-
In
yes,
this case, the Supreme Court held them to be dependent.
yes, my lord. But my lord, the wording said, my lord, having said, it must be necessary follow that even the major male married an earning zone of deceased, being legal representative, have a right to apply for compensation,
Yes.
and it would not be the bounden duty of the tribunal to consider the application irrespective of the fact whether the legal representative was fully dependent on deceased or not. Whether it is he is dependent or she is dependent or not, that is not, my lord, material, my lord. He has a right to have, my lord, right to file a compensation under section 166 of MB Act, my lord. And accordingly, my lord, this computation should be made in accordance with the judgment held by the Apex Court in Sarla Verma case. Thereafter, my lord, kindly, may I take your lordship to paragraph 20, page 8, my lord. In this case, my lord, the owner or the tribunal, my lord, the learned tribunal has given, my lord, has deducted the income of the deceased as 50%.
No, no. In this case,
Yes, my lord.
against loss of dependency and a compensation was awarded.
My lord.
But before that, High Court, Supreme Court observed that the claimant were in fact dependent on the income of her mother. In this case, before awarding compensation against loss of dependency,
Yes, lord.
court has treated them to be dependent of mother. Am I right or wrong?
My lord, in my humble understanding, my lord, legal representative, my lord.
No.
My lord,
You
yes,
come-
I'm coming to that point also, my lord.
You come to para 15.
Yes, my
Para
lord.
15, last line, read. In that sense,
Yes, my lord.
they were largely dependent on the earning of mother.
Yes, my lord. Therefore, my lord, 1/3 has been given. Not
Yes.
50% is not deducted. Earlier,
Yes,
tribunal.
because
Yes, my lord.
court treated them to be dependent.
Yes, ma'am. Therefore, 1/3.
Yes, correct.
In my case, 50%, my lord.
Because you are not dependent.
Yes, ma'am. That's why, my lord, my submission is, my lord, the learned tribunal has given me the compensation not on the basis of my dependency, my lord. On the basis I'm a legal representative of the client.
So
This is, my lord.
I have understood.
Yes, ma'am. That's why,
But what is your claim? What loss you have suffered?
my lord,
You have to be compensated for some loss.
yes, my lord. That is
What
pecuniary
ex-
loss.
No, he's saying that you have suffered loss of estate only. His submission is that you have only suffered loss of estate.
Yes, ma'am.
My query to you is, what other loss you have suffered?
My lord, so pecuniary loss is there. Other than that, my lord, dependency is not there.
No, everything is about pecuniary only.
Yes, ma'am.
Because here, all loss of dependency, any loss would be compensated in terms of money only.
Yes,
So loss is pecuniary only, but against which head you are suffering a loss? You are saying that you have not suffered loss of dependency.
Yes, ma'am.
Because in that you are in agreement with the counsel for the appellant.
Yes, ma'am. But, my lord, in Sarla Verma case, ma'am, this proposition of loss of estate has not been mentioned, ma'am.
Okay.
Yes, ma'am. It's only on loss of dependency, ma'am. Although they are not dependent, but he is entitled to claim compensation under section 167. 66. Legal representative has right to claim compensation under section 166 of MB Act. And, my lord, this formulation, my lord, this, my lord, methodology that has been, my lord, given in Sarla Verma case. Even I concede to his argument, my lord, if we take it is under the head of laws of the state also,
Okay.
but my lord, calculation will be same, because 25% is nowhere in, my lord, Sarla Verma
Okay,
case
I
or
understand.
Plena City case, my lord.
So according to you, the submission, the judgment of the tribunal should not be interfered with.
Yes, man, not be interfered with. And my lord, other they have not disputing, my lord. Even then, my lord, there are some, my lord, future prospect is also given, my lord. Future prospect, funeral expenses, that has been given, my lord, in terms of Sarla Verma case, my lord, in the line of judgment given in Sarla Verma case. My lord, page 44, man. Page 44, my lord. Award is there, my lord. This is, award is also there, my lord. But
Page?
this is, my lord, the judgment part, my lord. Page 44, my lord.
Yes.
My lord, pecuniary loss, that is, my lord, 16,76,454, my lord. Funeral expenses, 25,000. 30% computation future prospect is held in, my lord, Sarla Verma case, my lord. Since, my lord, he is 48 years old, the future prospect computing.
Where are you reading?
Page 44, my lord, of
Where?
the
Para?
PTC. My lord, page 44.
Page 44 is the impugned judgment only.
Yes, my lord.
Impugned judgment, which para?
My lord, this will be, my lord, para 88.
88.
88 thereafter, my lord. 43 is para 88. Para 88 is in 43 years.
So what is your submission?
My lord, computation, my lord, regarding this computation, my lord, I'm apprising the court. Pecuniary loss, my lord, that is 16,76,454. Funeral expenses is given 25,000. 30%.
30%.
Future prospect is for my Sarla Verma case. I have no any, my lord, dispute on that. I have no any submission. Only, my lord, I'm apprising the court.
Mr. Kato, you are disputing future prospect also. 30%.
30% of future
Yes,
prospect.
30.
No, he is not.
You give a calculation to me.
Yes, my lord.
Okay. Finish.
Yes, my lord, in my humble submission, my lord, in
Heard
understanding.
Mr.
Yes, my
G. Kato, learned counsel for the appellant, also heard Mr. H. Lampu, learned counsel for the respondent claimants. Let this case be listed for delivery of judgment on 31. Tomorrow I will declare. You give that calculation within an hour.
Yes, sir.
Tomorrow I will deliver the judgment
Obligement.
on 31/8/2000.
Obligement.
May I, Your Lordship? Your Lordship, I beg to mention item number 9, Your Lordship. This matter to be on listed next week, Your Lordship.
Item number.
I'm mentioning on behalf of S. Tapin, he's out of station, Your
But
Lordship.
it is at 2.
But
Mr.
I'm-
Partin will come.
Yeah, I'm fully
Okay,
I'm-
you're.
Yeah, Junior
presenting
is
Mr.
here. I've
Partin.
taken concern, Your Lordship.
You have no objection.
No, we don't have any objection.
Heard, miss, what is your name?
P. Pangu, Your Lordship.
P.
Pangu.
Pangu, learned counsel appearing for
On behalf of S.
Mr.
Tapin, Your
S.
Lordship.
Tapin. Praise for listing this matter
Next week, Your
in the
Lordship.
next week. Mr.
I'm Yube.
M. Yube, learned counsel for the respondent, raises no objection to the said prayer, hence the prayer is allowed. Let this matter be listed again in the next week on a date to be fixed by registry.
Bless Your Lordship.
May it please your lordship. Lordship, item number 1617, I apologize, my lord. The internet connection got disrupted, my lord.
But we have already passed orders.
My lord, on my lord's direction, I had filed the IA as a quick
No,
basis, my lord.
Though the public prosecutor submits that she has received the copy of the order, she has not received.
My lord, the IA,
She has
how
prayed
the-
for listing it in the next week.
I'm
You-
for the
My lord.
petitioner.
Petitioner,
Respondent in IA.
what is your submission?
The only submission is that since the conducting council is not here, then it may be adjourned for now.
When?
Uh,
You have received the copy of the.
yes, your lordship. Last
My
night.
lord, may I just submit here, my lord? If my lord, this is, my lord is very, very well known, my lord, that without
No,
serving copy.
No, I am not going on the merits because.
No, no.
What,
Yes, my lord.
what harm will cause if the interim order remains? What
Yes, my
harm-
lord. Just one line submission, my lord, in this.
Yes.
My lord, the order has been passed without looking in the CD. And they have been getting notice under section 41. Despite that, they have not participated in the proceeding. And this is affecting my case, which they have filed against me in the Jabalpur High Court. My lord, that is why the necessity of the investigation. If they investigate, my complaint is about obtaining the CDR call records of the respondent number 3, of the respondent number 4, and the petitioner. And if that is comes in the form of a CD or in form of a charge sheet, then it will help me in my case in Jabalpur.
No,
My lord, that they have.
Mr. Sharma.
Yes, my lord.
For vacating an interim order.
My lord.
Both parties are to be heard.
I absolutely understand, my lord.
They are
My lord,
seeking, they are seeking it to be listed next week, any date. You choose a date, we will fix it.
My lord, Monday. I have an urgency, my lord.
You suggest.
Your lordship, Monday not be possible because the conducting council is at his native town.
You
He will return by 9th, 10 or 11th.
So, is it okay if it is fixed on 9th?
9, yes, it will do.
9th.
My lord, 9th.
9th of
Must be.
September. Heard Mr. S.P. Sharma, learned counsel for the applicant. Also heard Mr. What is your name?
E. Payang, your lordship.
T. Payang,
Yes, your
learned
lordship.
counsel for respondent number 1, as well as Miss L. Hage, learned additional public prosecutor representing the state respondent. On request of the learned counsel for the respondent, let this matter be listed on 9th of September.
My lord, if both the councils agrees it to be on 12th, it's a Thursday. 12th is a
No, your
Thursday.
lordship. He'll be here on 9th, 10, 11th, and on 12th he's returning back again. After that, maybe on 17th, 18th.
No, my lord, it seems he's a
That's
busy
the
council.
issue.
So he seems it's a busy council. It's okay, my lord. I'll adjust myself for 9th, my lord.
9th.
Deeply obliged.
Much obliged.
How many matters are remaining? Only one. Give it to me. Unlisted you have gone through.
May I please, your lordship. I am owner of
Microphone.
I am owner of a vehicle which was stolen by someone, and thereafter the said car was used for carrying contraband, and thereafter the Balemu police station.
Contraband, how much?
Ganja.
Oh.
Thereafter, I cooperate.
CD would be required or not required?
Lordship, here lordship, as per the lordship, this this petition lordship, this already trial is started lordship.
Trial started.
Lordship. Lordship, here lordship.
You have been charge sheeted.
Charge
sheet is there, his name is
Against
reflected. Yes, lordship. And lordship, moreover, lordship, his he has been called for lordship, for appearance lordship on 26th of November 2024 lordship, on the next month lordship.
Before the trial court.
Lordship.
Lordship,
Lordship.
during the period of investigation, I cooperate with the IO and recorded my statement. Thereafter, surprisingly, they filed the absconder charge sheet and thereafter issued summon. And accordingly, I represented before the trial court. I approached before this honorable court as the charge sheet has been charge sheeted, showing absconder.
Now you
Lordship,
have received summons.
yes, Lordship.
You have appeared before the court.
Yes, I will appear and facing the trial.
No, but the charges are under 20B to C,
That's
where
why-
you cannot be granted bail.
That's why that is suspected. I had cooperated with the IO. A statement has
Those
been
questions
recorded.
does not arise. Even if you have cooperated, whether bail can be granted under 37, you show me. Because how much ganja was,
I am honored. My
I know you are honor in your submission is that without your knowledge, your vehicle was used. But during investigation, it was found that you are involved. Therefore, charge sheet has been laid against you. Unless you challenge that charge sheet remains where incriminating materials, where you are shown as one of the accused against whom charge sheet has been filed. You are not shown as an accused, not sent up for trial. Some materials are found against you. Therefore, charge sheet has been filed. So unless you challenge the charge sheet, 37 will always be there.
The IO has nothing found against me.
For
They-
that, we have to examine the charge sheet.
Uh,
For that, we have to examine the charge sheet or not.
yes.
To consider your submission that nothing was found, there is no material, unless we examine the charge sheet. What is your submission?
Lordship, here, Lordship, as per the charge sheet, Lordship.
Charge sheet is there with you.
Yeah, Lordship, the annex, Lordship.
Okay.
They have annex, Lordship, in the page 23 onwards. Or just page 22 onwards, or 21 onwards, Lordship.
If you can show that nothing is there against you, then only you will get bail.
Yes.
But for showing that CD and charge sheet has to be there.
Only they suspected. And movement order has been passed. Page number 15, kindly see that the vehicle was stolen by someone. Page number 15.
What is this?
I had lost an FIR. Accordingly, Superintendent of Police issued this movement order to bring the said my vehicle.
No, Lordship, this is not the, in the base of their FIR, Lordship. This is the Office of Superintendent, the movement order, Lordship. Whereby the additional Director General Police, the following police team of Kamruk under the leadership of SI in the stolen vehicle, Lordship. in
Page
connection
number,
with-
page number?
Page number 15.
But as per the Lordship, this charge sheet, Lordship, it
Page
is
number
Lordship,
15.
Where is your FIR
Lordship, I
that
have-
your vehicle has been stolen?
Lordship, that's why I have not enclosed
it's not
in
enclosed,
this,
Lordship.
in this petition.
That is your basis.
Yes,
Yeah.
Lordship, may I, Lordship,
Yes.
page 25, Lordship, in the charge sheet. in the third paragraph, Lordship, while the case was under investigation, a team from
First
police-
paragraph,
Paragraph third, Lordship, page 25.
third, yes.
Yes, Lordship. While the case was under investigation, a team from Assam Police of Hajo Police Station reported at Bolemo PS number 161221 to take into their possession the seized vehicle on the ground that the owner of the vehicle, namely Sri Bapukon Das, had lodged a vehicle missing complaint at the Hajo Police Station. The seized vehicle was not released to the Assam Police as the investigation was at the early stage and proper verification of involvement of the owner in the instant case was to be done. After that, as directed, the owner of the vehicle, Sri Bupukon Das, appeared at PS Balemo along with a copy of the FIR of the Hajo Police Station number this 380 IPC. As per the FIR, the missing case was registered at Hajo PS on 21/11/21. And after 4 days from the occurrence, registration of the incident case at Balemo Police Station. The previous IO allowed the owner to go on further verification from the OC Hajo whether any vehicle missing report was made at Hajo Police Station a day or 2 days before the registration of the scene number this Lordship. The previous IO visited the Hajo police station and recorded that no missing FIR of the seized vehicle was made by the owner a day or 2 days before the registration of the Hajo PS case number 1962-21, which does not corroborate with the statement given by the Bupukon Das. Since then, the vehicle owner Sri Bupukon Das is absconding. Raid was conducted at his residence situated at village Japia, which is about 10 to 12 kilometers deep inside a remote village area. He could not be offended. Accordingly, NBW against him was obtained from the Honorable Court of Session, Judge Bomdila. The wife of the vehicle owner reported that the vehicle was parked at the entrance side of the house. In the FIR lodged by the Bupukon Das at Hajo Police Station, the date of missing of vehicle has shown as 15/11/21, whereas the missing FIR was lodged and registered on 21/11/21. On the sixth day from the above, it is evident that the alleged accused Bupukon Das and the driver of the seized vehicle, Muhammad Ali, had well-planned motive and by lodging FIR at Hajo PS wanting to get themselves exonerated from the crime. The seized exhibit was sent to the
When the FIR was lodged in this case,
Check. In this case, it is clearly stated in my statement recorded by the
no, where is the FIR? Where is the FIR? The
Yeah.
present FIR.
information.
Eighteen 11.
They have not annexed Lordship the missing FIR copy. The missing report of the FIR copy.
So police is saying that FIR was registered on 21/11
Lordship,
and the incident here occurred on 18/11.
Lordship.
So this FIR you have filed after your vehicle was seized,
Lordship, that's why
after
Lordship.
you came to know that it,
No, Lordship, immediately I informed
on which date?
informed the father registered and was lost on the 21/11. I have no knowledge that seizure by the
Where is the FIR which have you?
Lordship, I have not enclosed the copy which is
No, but the charge sheet says that though you have alleged that you lost the FIR on 15/11, it was actually registered on 21/11.
Lordship.
Whereas before that, on 18/11, the contraband was seized.
Lordship.
So the IO has concluded that only to save yourself, you have lodged a false FIR in.
that's why they suspected on that ground. Only suspected.
Their lordship, the IO also visited the Haju police station, lordship, and no, there are no record as such found, lordship.
Yes, in Haju police station, no record was.
Lordship, that's why, lordship. They said that prima facie well
Therefore,
established.
there are grounds against you. This is not a fit case.
Lordship, main order has been passed on the basis of this FIR. Case number
Otherwise,
15.
lordship, they can approach the lordship, this
Kindly
special court for the bail, lordship, because they have already, they
case number
have
15.
called for appearance on 26, lordship.
I am reading it in anticipation of
Movement order on which date?
this order 10/12/2021 to bring this.
No, that is much after.
Lordship.
The IO's case is on 18/11, ganja was apprehended from your vehicle.
Yes,
Thereafter, on 21, you lost an FIR.
I have lost, yes, it is
That-
fair. It is fair. Immediately I had informed the police, but thereafter.
But the IO went to Haju police station. You are saying that you have lost FIR on 18/11.
Yes. That's why IO has suspected. That's why on that ground, the IO has suspected. Even I have appeared before the IO of the Balangu police station.
And what other materials are there regarding this? You have not challenged the charge sheet.
Lordship.
Now,
yes, sir.
charge sheet materials are against you.
No.
So bail, it is not a fit case for them.
And moreover, this is lordship 21, this clause of clause 3 lordship, this is a commercial quantity lordship.
Therefore, 37
Lordship,
comes.
37,
Otherwise,
he have to lordship convince before the court why bail to be granted lordship.
Like, as I am owner, police has not recovered from my position, and I have no knowledge of such contraband, and accordingly, I have cooperated with the IO. Statement has been recorded by the IO.
then charge sheet has been wrongly filed against you.
But surprisingly, why they so.
No, is it your submission that charge sheet has been wrongly filed? Is it wrongly filed? Yes or no?
Wrongly,
You are not answering my query.
I was available before the IO.
No, that is not my question. My question is whether charge sheet has been wrongly filed against you without any materials
Yes.
against you.
Okay.
Yes or no?
Yes.
Then you challenge the charge sheet.
Wrongly, they suspected on that ground also.
Heard, Mr.
Lordship, I will face the trial proceedings.
Heard, Mr. What is your name?
Yes, Lord.
Yes, Government Learned Counsel for the petitioner. Also, what is your submission?
Lordship, my submission is there, lordship. Told the lordship, this is the commercial quantity lordship, and he is already lordship, the trial is begun, and charge sheet is prima facie well established the case against him. Our lordship, let the lordship, he may appear before the lordship. At this stage, bail may not be granted lordship, because lordship 37 is dear lordship, as lordship has rightly pointed out. And at this
And
stage,
he is unable to make out his case.
lordship,
That
and
is-
moreover, lordship, I'm fail to understand how he's not under custody till now, lordship, because lordship,
That will see, the long trial court, I will face the trial court.
No, therefore you appear before trial court, you
I will appear.
pray for bail before
lordship,
trial.
he can do that, lordship.
You pray for bail before trial court. By giving that observation, we are,
Till the next day, and,
no, till the, when is the next day?
26/9.
26 September,
There
lordship.
is no warrant issued against you. Then where is the apprehension? You will otherwise not be arrested.
That's they filed. the-
His only apprehension, lordship, that charge sheet is against him, that's why he have come up
But
in the
there
NCT
is
bail.
no pending warrant, nothing else. Yes, Mr. Burman.
Lordship,
Also heard Mr. L. Hage, learned. Eddie, I have given sufficient time to.
Lordship, in the charge sheet, I reflected that one time warrant has been issued in the charge sheet.
During investigation,
Hmm.
during investigation, warrant was taken. Now, when the charge sheet has been laid before the court, unless court issues fresh warrant, you will not be arrested. Court will issue summons to you,
Yes, sir.
you appear before the court, and if court is convinced, you will get bail, otherwise not.
That's right.
And there is unlikelihood because of 37 that trial court would grant you bail.
Yes.
This application under section 482 of BNSS 2023 has been filed by the petitioner Bapukon Das, who is apprehending his arrest in connection with Bomdila or Balemu, Balemu in connection with NDPS case number 2/2024 pending before learned special judge NDPS Bomdila, corresponding to Balemu PS case number 12/2021. So, learned counsel for the petitioner has submitted that on the basis of an FIR which was lodged on 18/11/2021 by one Shri Ravi Singh, wherein allegation was made regarding recovery of 100 kgs of ganja from the vehicle number AS25EC 727624, Balemu PS case number 12/2021 was registered and investigation was initiated. Ultimately, on completion of investigation, charge sheet was laid.
Lordship, may I, Lordship, in the order dated 21/3/24 also, Lordship, while the consideration of charge sheet, Lordship, the court has found that the accused person is involved, Lordship. That's why, Lordship, the court has they have charges under 20B23 NDPS, where it is, Lordship, court has also found that during investigation they involved the this accused person
Charges were
involved.
framed.
Lordship.
Framed.
Lordship, it is found sufficient. It is
Cognizant,
21/3/2024. Where there are sufficient measure of commission of offense and accordingly cognizance of the same is taken.
Cognizant.
Cognizance of taken, Lordship, not charges framed. This is taken.
What was the last line? Charge sheet was laid, showing the charge sheet was laid against two accused persons, and the present petitioner was shown as an absconder therein. Learned counsel for the petitioner has submitted that the petitioner had cooperated in the investigation and he is no way involved in the offense alleged in the charge sheet. He submits that the vehicle from which the contraband was recovered belongs to him. However, it was stolen before the alleged incident and stop. He also submits that with regard to theft of his vehicle, he had also lodged an FIR before the Hajo police station on 18/11/2021. Stop. He submits that as the petitioner has been shown as an absconder in the charge sheet, he apprehends that he may be arrested at any time. On the other hand, learned additional public prosecutor has submitted that on perusal of the charge sheet, it appears that the plea of theft of vehicle taken by the petitioner has been only a ploy to
No,
save himself
No, sir. From the
From-
charges.
from getting involved, from getting incriminated in the case. As the she submits that the investigating officer had visited the Hajo
Hajo
police station
police station.
also during the course of the investigation and found that
No missing FIR was, no missing FIR of the seized vehicle was made by the owner either 2 days before the registration of the Hajo PS number. It is here in the
has
charge sheet.
found that the Hajo PS case number 1962/2021 was registered on the basis of the FIR filed by the present petitioner only on 21/11/2021.
No, sir.
That is after
After
3 days
3
of
days
the
of the,
alleged incident in the instant case.
no, sir. 3 days of the seizure of the vehicle with all
Yes.
contraband.
And she also submits that as the
And
contraband,
after that, he's stating that his vehicle was stolen before 5 days from his home, no, sir.
is also submitted by learned additional public prosecutor that as the contraband seized in this case is of commercial quantity, the embargo of section 37 of the NDPS Act comes into play, and therefore she opposes the grant of bail to the present petitioner. So I have considered the submissions made by learned counsel for the contesting parties and peruse the materials available on record. Stop. In this case, it appears that the charge sheet has been laid showing the present petitioner as an absconder, and the next date of the case is fixed on
26/9,
26/9/2024
24.
for appearance. And as submitted by learned counsel for the petitioner, only summons have been issued. Summons have been issued to the present petitioner. Hence, this court is of considered opinion that as no pending warrant is against the present petitioner, there is presently no apprehension of getting arrested
Yes, sir.
in connection with the
Panama PS number 1221.
NDPS case number 2/2024. This anticipatory bail application is accordingly disposed of with a direction to the petitioner to appear before the trial court on the next date fixed, that is on
26/9.
26/9/2024. The petitioner may file a bail application before the said court on such appearance if so advised. If he files any bail application, the trial court shall consider it in accordance with law. This bail application is accordingly disposed of.
Yes. Obliged.